Bismillah ar-Rahman ar-Rahim wa salatu wassalam ala ashraf al-mursaleen. We are going to proceed on page 192, Commercial Law for Business Students for Al Isra University students, and started with distinction between directors and shareholders. Distinction between directors of the company and shareholders of a company. A company is an artificial legal person recognized in law as having an existence distinct from that of its members. Once incorporated, the members, shareholders of a limited company, enjoy limited liability. As long as they have paid for their shares in full, they cannot be required to contribute to the debts of the company. It is important to recognize that ownership and management of a company can be separate, even though the individuals concerned are physically the same. Shareholders, as owners of the equity or share capital of the company, have the right to freely transfer their shares unless there is some restriction in the company's constitution. Shareholders, however, have no authority to change by business of the company. Directors exercise day-to-day management of the company subject to the Companies Act. The memorandum and articles of the company and the directions given by the members of the company by special resolution at a general meeting. Shareholders have the following right to virtue of owning shares in a company. Number one, to receive dividends as money or shares, to receive a return of capital in a winding up. 3, to participate in surplus assets on a winding up. 4, to attend and vote at general meetings. Shareholders have no right to see the minutes of directors' meetings, only of shareholder meetings. Their decisions at general meetings may, in some instances, require a 75% majority. Directors are appointed by the company in accordance with its articles of association. Their activities are controlled by the articles, which deal with appointment, qualification, rotation, and remuneration, and by the Companies Act, company directors' disqualification rules, and insolvency rules. Directors have a fiduciary duty of good faith towards the members of the company. Every director must give notice to his company of any interest which he has in the shares and the debentures of the company. Directors can be removed from the board of company without their consent under the provisions of law. Directors cannot vote or participate in a board meeting discussion to consider a matter in which they have an interest unless they have given prior notification of the interest. Generally, directors may consider whatever matters they consider necessary to be discussed at a board meeting, and they reach decisions by a simple majority vote. In many small companies, for example, husband, wife, partner, or family companies, the directors and shareholders are the same. In this case, it is important to realize that the above provisions of the company law apply. This is particularly critical in the event of liquidations, where directors of companies ensure that their own assets are kept separately from those of the company in which they are the only shareholders. We're going to move to page 195 and talk about section 3, forming a company. How to form a company. Promoting the company. The promoters of the company are the people who actually set it up, but not including a lawyer, accountant, or other professional providing services to assist the process. The promoter's role varies, but it always involves the formalities of registration. It may also involve finding directors and obtaining premises, plant, and equipment. However, these later functions may not be required of promoters, since large numbers of companies do not start from scratch or on being registered. They have their origins in an established small business, for which incorporation is the next logical step. The promoters of such a company will usually move from being partners to directors. Promoters' liability for pre-incorporation contracts are personally liable for all contracts entered into force. The company has completed the registration process, even if made in the name of the future company. This is entirely logical, since the company does not exist as an independent being until its registration is complete. While it may be essential for the promoters to make contracts on behalf of the business before incorporation, they cannot be treated as the agents of the company, since it has no independent existence at this point. Therefore, it cannot legally authorize the making of a contract. Even when it is incorporated, it cannot ratify any contracts made before incorporation brought the company into being. Thus, it is fair to give the other party to the contract the right to sue the promoters if the contract is not performed. The promoters may sue or be sued on such contracts regardless of whether the other party knew that the company did not yet exist. The claimant knew that the company was still at a pre-registration stage, but this didn't prevent him from suing the defendant for breach of contract at this point. The law allows promoters to provide personal liability by express agreement with the other party to the contract. Such agreements fall into two kinds. Number one, the contract may stipulate that the liability of the promoter will cease once the company has been registered and has entered into a contract on the same terms. Number two, gentleman's agreement. The promoter may enjoy complete immunity if the other party agrees to enter into a gentleman's agreement for which the intention to form a legally binding relationship is excluded. This means that in reality, the pre-incorporation contract does not have the status of a contract at all. Forming the company. A company is formed by one or more persons signing a memorandum of association and complying with the registration process as prescribed by the law. Note that it is possible for a company to consist of one member, which helps small business to register.